as I have conveyed to you that Article 13 is an important protective shield for the fundamental right. Now, when we talk about the various judicial pronouncement or judgment related to Article 13, one of the major important judicial pronouncement is an A.K. Gopalan case of 1950. It was against the state of Madras, in which the Honorable Supreme Court had taken a very stereotypical view of the fundamental right, and they had seen each right under the Part 3 of Indian Constitution as separate, as independent to each other. Okay, they haven't seen any kind of nexus in between them. So, in this particular judgment, they have pronounced that the preventive detention under a valid law was held constitutional because, as per the Supreme Court, it didn't violate Article 21. Okay, and this is all because of the narrow reading of Article 21 कि जो preventive detention है, ठीक है, वो किसी भी हद तक जाए, किसी भी हद तक प्रताड़ित करे to for the prisoner or to the inmates. Okay, it is not going to be treated as unconstitutional. That was regarding A.K. Gopalan case. A.K. Gopalan was a very famous communist leader. Then the next judgment related with Article 13 is Shankari Prasad versus Union of India. This judgment had been given in 1951. The major question which arose with respect to this particular case is, does Article 13 includes Constitutional Amendment Act or not? Okay. So in this particular judgment, the Supreme Court had pronounced that under Article 13 you can't include the Constitutional Amendment Act. Very categorically they have said no. They said law in Article 13 means the ordinary law, Sadharan law, and not the Constitutional Amendment Act. So the Parliament could amend the fundamental right. That was the pronouncement of the Honorable Supreme Court in Shankari Prasad case of 1951. Then we have an important judgment in 1967, which is also famous with respect to doctrine of prospective overruling. That is Golaknath versus State of Punjab. This particular judgment, it reversed what the Supreme Court had said in Shankari Prasad case. In this particular judgment, Supreme Court had said that even the Constitutional Amendment Act, it comes under the ambit of law under Article 13 subclause 3. Okay, so in this particular judgment, Parliament called fundamental right as sacrosanct. Okay, that was the whole spectrum with respect to important judgment of